So if you like chocolate covered fruit, cannabis, or you're a small business owner who wants to learn about brand protection, you're going to want to hear about this hot topic. Edible Arrangements, the company, recently dismissed without prejudice its litigation against Green Thumb, a company who was selling cannabis-filled products under the trademark of Incredibles. For years, Edible Arrangements has been claiming in its complaint that this Green Thumb brand has infringed on the Edible Arrangements trademark. Many people may not know this, but Edible Arrangements actually sells a brand of CBD products called Incredible Edibles. Now, Incredibles, which is Green Thumb's brand for marijuana and cannabis-based products, is not a federally registered trademark. The products under the Incredibles brand does derive from THC, which means it is not federally protectable by a United States trademark. In the complaint, Edible Arrangements claims that in some of its stores, it is expanding into CBD products since they were made legal by the federal government. Of course, only those products that are derived from hemp can be sold for different uses, medical and otherwise, in stores in some states. And so Edible Arrangement says that they are already entering that field, and so anything that is in that field that has the edible wording or phrasing is confusingly similar to its customers. Now, while Edible Arrangements does have a pretty thorough trademark portfolio, that does not mean they can stop anyone who uses the word edible. Had this case not been dismissed, which they can bring up later because it was dismissed without prejudice, Edible Arrangement would have to prove through the DuPont factors that these two trademarks are confusingly similar to customers, and therefore the Incredibles, the brand owned by Green Thumb, should not be allowed to be used. Here's a quick review of the DuPont factors. Generally, are the items similar in their sound, appearance, or general connotation? Are the goods and services between the two competing brands similar at all? Are they both from cannabis? The similarity or dissimilarity of the trade channels, like where are these things sold? Are one thing sold at a gas station and another one at a hair salon? What are the conditions of the purchasers when they're making their purchases? Are these things that people get from an impulse buy, or are these very careful buyers who are looking for a particular type of, Rolex? The DuPont factors also considers the number of other similar marks that are out there. And they also look if the two parties had any particular business relations prior to the lawsuit. Edible Arrangements claims they dismissed this lawsuit because of changes to a lot of state laws allowing more cannabis and THC use in different sales channels. Those differences changed the case, and so they're waiting to maybe file later.